Welcome to This Week in Education Law School Administrator's Guide, episode number 14. This week, I'll focus on a case about whether an educator's free speech in classroom is protected by the First Amendment. I'll first introduce the case Meriwether v. Hartop 2021. I'll then briefly discuss the recent argument used by lawyers for the state of Florida in their court filing to defend the Individual Freedom Act, which took effect on July 1st, 2022. Let me first introduce Meriwether v. Hartop 2021. Nicholas Meriwether was a philosophy professor at Shawnee State University, a small public university in Ohio. Up until the incident that triggered this lawsuit, Meriwether had a spotless disciplinary record. He was also a devout Christian, believing that God created human beings as either male or female, and that this sex is fixed in each person from the moment of conception, and that it cannot be changed, regardless of an individual's feelings or desires. Meriwether also believed that he could not affirm as true ideas and concepts that are not true. In 2016, at the start of the school year, the university emailed the faculty informing them that they had to refer to students by their preferred pronouns. Meriwether asked university officials for more details about the new pronoun policy, and the officials confirmed that professors would be disciplined if they refuse to use a pronoun that reflects a student's asserted gender identity. The university's policy applied regardless of the professor's convictions or views on the subject. Meriwether approached his department chair to discuss his concerns about the pronoun policy. Knowing that Meriwether had successfully taught courses on Christian thought for decades, the department chair said that Christians are primarily motivated out of fear and should be banned from teaching courses regarding that religion. In her view, even the presence of religion in higher education is counterproductive. Meriwether continued to teach students without incident until January 2018. On the first day of class, Meriwether was using the Socratic method to lead discussion in his course on political philosophy. When using that method, he addressed students as Mr. or Mrs. He believed this formal manner of addressing students helps them view the academic enterprise as a serious, weighty endeavor and fosters an atmosphere of seriousness and mutual respect. He believed that addressing students in this fashion is an important pedagogical tool in all of his classes, but essentially in political philosophy, where he and the students discuss many of the most controversial issues of public concern. In that first class, one of the students Meriwether called on was Doe. According to Meriwether, no one would have assumed that Doe was female based on Doe's outward appearances. Meriwether responded to a question from Doe by saying, "Yes, sir." This was Meriwether's first time meeting Doe, and the university had not provided Meriwether with any information about Doe's sex or gender identity. After class, Doe approached Meriwether and demanded that Meriwether refer to Doe as a woman and use feminine titles and pronouns. This was the first time that Meriwether learned that Doe identified as a woman. So Meriwether paused before responding because his religious belief prevented him from communicating messages about gender identity that he believed were false. Meriwether explained that he wasn't sure if he could comply with Doe's demands. Doe became hostile, circling around Meriwether at first, and then approaching him in a threatening manner. Doe promised that Meriwether would be fired if he did not give in to Doe's demands. Meriwether reported the incident to senior university officials, including the dean of students and his department chair. University officials then informed their Title IX office of the incident. Officials from that office met with Doe and escalated Doe's complaint to the acting dean of the College of Arts and Sciences. The dean went to Meriwether's office the next day. She advised that Meriwether eliminate all sex-based references from his expression, not using he or she, him or her, Mr. or Mrs., and so on. Meriwether pointed out that eliminating pronouns altogether was next to impossible, especially when teaching. So he proposed a compromise. He would keep using pronouns to address most students in class, but would refer to Doe using only Doe's last name. The dean accepted this compromise, apparently believing it followed the university's gender identity policy. Doe continued to attend and participate in Meriwether's class, but Doe remained dissatisfied and 2 weeks into the semester complained to university officials again. The dean paid Meriwether another visit. This time, she said that if Meriwether did not address Doe as a woman, he would be violating the university's policy. Soon after, Meriwether accidentally referred to Doe using the title Mr., and he immediately corrected himself. Around this time, Doe again complained to university's Title IX coordinator and threatened to retain counsel if the university didn't take action. The dean again came to Meriwether's office. She reiterated her earlier demand of addressing Doe as a woman. The dean also threatened disciplinary action if Meriwether did not comply. Trying to find common ground, Meriwether asked whether the university's policy would allow him to use students' preferred pronouns but play a disclaimer in his syllabus, noting that he was doing so under compulsion and setting forth his personal and religious beliefs about gender identity. The dean rejected this option out of hand. She insisted that putting a disclaimer in the syllabus would itself violate the university's gender identity policy. After the meeting, the dean sent Meriwether a formal letter reiterating her demand. Address Doe in the same manner as other students would identify themselves as female. The letter said that if Meriwether did not comply, the university may conduct an investigation and he could be subject to informal or formal disciplinary action. A few days later, and without waiting for a response from Meriwether, the dean announced that she was initiating a formal investigation. She claimed that she was doing so because she received another complaint from a student in Meriwether's class. The complaint was again from Doe. When Meriwether again asked whether an accommodation might be possible given his religious belief, the dean said Meriwether had two options: stop using all sex-based pronouns in referring to a student, a practical impossibility that would also change the pedagogical environment in his classroom, or refer to Doe as a female, even though doing so would violate Meriwether's religious beliefs. The dean referred the matter to the university's Title IX office. Over the coming months, the university's Title IX staff conducted a less than thorough investigation. They interviewed just 4 witnesses: Meriwether, Doe, and 2 other transgender students. They did not ask Meriwether to recommend any potential witnesses. And aside from Doe and Meriwether themselves, none of the witnesses testified about a single interaction between the two. The university's Title IX office concluded that Meriwether's disparate treatment of Doe had created a hostile environment in violation of the university's non-discrimination policies. Those policies prohibit discrimination against any individual because of gender identity. They defined gender identity as a person's innermost concept of self as male or female or both or neither. And they defined a hostile educational environment as any situation in which there is harassing conduct that limits, interferes with, or denies educational benefits or opportunities from both a subjective, the complainant's, and objective, reasonable person's viewpoint. The Title IX report concluded that because Doe perceives themselves as a female, and because Meriwether has refused to recognize that identity by using female pronouns, Meriwether engaged in discrimination and created a hostile environment. The report did not mention Meriwether's request for an accommodation based on his religious beliefs. After the Title IX report was issued, the dean informed Meriwether that she was bringing a formal charge against him under the faculty's collective bargaining agreement. The dean then issued her own report setting forth her findings. Because Dr. Meriwether repeatedly refused to change the way he addressed Doe in his class due to his views on transgender people, and because the way he treated Doe was deliberately different than the way he treated others in the class, he effectively created a hostile environment for Doe. The dean concluded that it was necessary to discipline Meriwether and recommended placing a formal warning in his file. Provost reviewed the dean's disciplinary recommendation before it was imposed. Meriwether wrote Provost a letter stating that he treated Doe exactly the same as he treated all male students, that he began referring to Doe without pronouns and by Doe's last name as an accommodation to Doe, and that Doe's access to educational benefits and opportunities were never jeopardized. It is important to note here that Doe excelled and participated as much and more than any other student in the class. At the end of the semester, Meriwether awarded Doe a high grade. This grade reflected Doe's very good work and frequent participation in class discussions. Meriwether further explained that he could not use female pronouns to refer to Doe due to his conscience and religious convictions. He asked Provost to allow reasonable minds to differ on this newly emerging cultural issue. Provost rejected Meriwether's request, stating that he approved Dean's recommendation of formal disciplinary action. The provost did not address Meriwether's arguments, nor did he grapple with Meriwether's request for a religious accommodation. The university placed a written warning in Meriwether's file. The warning reprimanded Meriwether and directed him to change the way he addressed transgender students to avoid further corrective actions, which means suspension without pay and termination, among other possible punishments. The university faculty union filed a grievance on Meriwether's behalf. It asked the university to vacate the disciplinary action and allow Meriwether to keep speaking in a manner consistent with his religious beliefs. The university faculty union filed a grievance on Meriwether's behalf. It asked the university to vacate the disciplinary action and allow Meriwether to keep speaking in a manner consistent with his religious beliefs. The provost, who had already rejected Meriwether's claim once, was tasked with deciding the grievance. A union representative joined Meriwether to present the grievance at a hearing. From the outset, the provost exhibited deep hostility. He repeatedly interrupted the representative and made clear that he would not discuss the academic freedom and religious discrimination aspects of the case. The union representative tried to explain the teachings of Meriwether's church and why Meriwether felt he was being compelled to affirm a position at odds with his faith. At one point during the hearing, the provost openly laughed. The provost was so hostile that the union representative was not able to present the grievance. The provost denied the grievance. The next step in the university's grievance process was an appeal to the university's president. But by the time of the appeal, the provost who denied the grievance was appointed interim university president. The president designated two of his representatives to meet with Merriweather. They were university's labor relations director and the general counsel. They agreed with the union that Merriweather's conduct had not created a hostile educational environment. They said this was not hostile environment case, but a differential treatment case. So they recommended ruling against Merriweather. Their argument of not a hostile environment case contradicted the Title IX investigation and the dean's disciplinary recommendation, both of which accused Merriweather of violating university policy by creating a hostile environment for Doe. The university officials justified the university's refusal to accommodate Merriweather's religious beliefs by equating his views to those of a hypothetical racist or sexist. Since the university would not accommodate religiously motivated racism or sexism, it ought not accommodate Merriweather's religious beliefs. The university president adopted his representative's findings and denied the grievance again. Out of options at the university, Merriweather filed a lawsuit alleging that, among others, the university violated his rights under the free speech and free exercise clauses of the First Amendment. The district court for the Southern District of Ohio at Cincinnati dismissed the professor's free speech and free exercise claims. But the Court of Appeals for the Sixth Circuit saw things differently and reversed the district court's decision on free speech and free exercise claims. Let's first look at Merriweather's free speech claim. Is a professor's speech in the classroom protected by the First Amendment? The Sixth Circuit's answer is yes, and the U.S. Supreme Court's Garcetti decision does not apply to university environment. In Garcetti case, the Supreme Court held that when a public employee makes statements pursuant to their positions as a public employee rather than a private citizen, their speech has no First Amendment protection. This is the argument used by lawyers for the state of Florida in their court filing to defend the Individual Freedom Act, which took effect on July 1st, 2022. The act amended the Education Code to enumerate actions that constitute discrimination on the basis of race, color, national origin, or sex, and are thus prohibited under Section 1000.054A. The Act prohibits the practice of subjecting any student or employee to training or instruction that espouses, promotes, advances, inculcates, or compels such student or employee to believe any of 8 enumerated concepts. For example, the Act prohibits teachers from endorsing the proposition that members of one race are morally superior to members of another, that individuals are inherently racist solely by virtue of their race, or that a person's moral character is necessarily determined by his or her race. Believing these concepts to be reprehensible, the Florida legislature has directed that they cannot be endorsed in the instruction provided to students in Florida's public universities. In its defense, the legal counsel for Florida Board of Governors of the state university system argued that multiple courts have recognized that Garcetti's reasoning applies to public school teachers providing instruction. This would mean that educators' speech in classroom is considered as the speech made by a public employee, not a private citizen, and their speech has no First Amendment protection. Here, the Sixth Circuit reasoned that the academic freedom exception to Garcetti covers all classroom speech related to matters of public concern, whether that speech is germane to the contents of the lecture or not. The need for the free exchange of ideas in the college classroom is unlike that in other public workplace settings, and the professor's in-class speech to his students is anything but a speech by an ordinary government employee. The Sixth Circuit wrote, if professors lacked free speech protections when teaching, a university would wield alarming power to compel ideological conformity. A university president could require a pacifist to declare that war is just, a civil rights icon to condemn the freedom riders, a believer to deny the existence of God, or a Soviet emigre to address his students as comrades. That cannot be. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe such orthodoxy. The court concluded that Meriwether was speaking on a matter of public concern, and his decision not to refer to Doe using feminine pronouns did not inhibit the student's education or ability to succeed in the classroom. Even the provost, who was later appointed to the interim president, admitted that Meriwether's conduct was not so severe and pervasive that it created a hostile educational environment. With the Supreme Court's Garcetti decision, the Sixth Circuit's ruling on Meriwether's case, and many other cases in the judicial process, there is a great deal of uncertainties over the extent to which the state can dictate what state college instructors teach. I'll keep track of the latest development of this issue. As for the free exercise claim, the court applied the strict scrutiny to universities' actions. To pass this scrutiny, the university actions have to advance a compelling interest and are narrowly tailored in pursuit of those compelling interests. The court noted that the university's alleged basis for disciplining Meriwether was a moving target. The Title IX report claimed that Meriwether violated the university's gender identity policy by creating a hostile educational environment. The dean agreed and recommended disciplining Meriwether for this hostile environment. But when Meriwether grieved his discipline, university officials conceded that Meriwether had never created a hostile environment. Instead, they said the case was about disparate treatment. Next, at oral argument, the university changed its position once again. It said that this really is a hostile environment case. These repeated changes in position, along with the alleged religious hostility, permit a plausible inference that the university was not applying a pre-existing policy in a neutral way, but was instead using an evolving policy as a pretext for targeting Meriwether's beliefs. The court also noted that the university's policy on accommodations was a moving target. When the dean told Meriwether that he was violating the university's gender identity policy, Meriwether proposed a compromise. He would address Doe using Doe's last name and refrain from using pronouns to address Doe. Dean accepted this accommodation. But several weeks later, she retracted the agreed-upon accommodation and demanded that Meriwether use Doe's preferred pronouns if he intended to use pronouns to refer to other students. Now the university claims that its policy does not permit any religious accommodations. Also, the university's Title IX investigation raises several red flags. The Title IX investigator interviewed just 4 witnesses, including Meriwether and Doe. She did not interview a single non-transgender student in any of Meriwether's classes, nor did she ask Meriwether to recommend any potential witnesses. Indeed, except for Meriwether and Doe, not a single witness testified about any interactions between the two. Even so, the Title IX officer concluded that Meriwether created a hostile environment. The university's Title IX report did not explain why declining to use a student's preferred pronouns constituted harassment. Moreover, the university did not grapple with Meriwether's request for an accommodation based on his religious beliefs. The court concluded that the university failed to argue that its actions were narrowly tailored to serve a compelling interest, and the court ruled in favor of the professor. After the court ruling, it was reported that the university paid the Professor Meriwether $400,000. In this video, I primarily discussed the public educators' free speech in classrooms. As I said earlier, there is a great deal of uncertainties over the extent to which the state can dictate what state college instructors teach. I'll keep track of the latest development of this issue. I'll see you next week in This Week in Education Law, School Administrator's Guide.